Thank you for joining me to our last episode or the last webinar of our Advanced Care Planning webinar series. Today we'll talk about last will and testaments and why are they important in your advanced care planning journey. This webinar is being recorded. Feel free to ask any questions in the chat or QA. I will make the slides as well as the recording available for you after the webinar. So a note before we begin, this webinar is part of a webinar series. So it works with conjunction with all the information that we have shared with all the previous webinars. All the information that I'm providing for you today is Colorado specific. Some of the language could be similar in other states, but please do remember that every state has their own rules, regulations about what constitute a last will and testament for that particular state. Also, a quick reminder, CGS, the Society, provides assistance to complete your advanced directives completely free of charge. Please feel free to reach out to me and we could go ahead and set up a time for us to chat or meet virtually so I could assist you with that process. Also, all of the forms that we have discussed in previous webinars, as well as the information that I'm providing you today, you could find it in our website. So that's senioranswers.org. And even though the society focuses on older adults, we do promote advanced care planning for everyone over the age of 18. So as I've been telling you every webinar, advanced care planning in the way that we see it at the society, it's very comprehensive, and we want to make sure that you prepare yourself in all in all aspects. That includes medical, financial, and legal. So the aspect that we're talking about today is legal. So my objectives for you today is to understand what is a living will and testament, how does it differ from all the other advanced directives that we've talked about, and why is this one different than the medical and financial directives that we've talked about. So that way you could understand why this could be a very important tool for your advanced care planning. Also, I will cover best practices and what information you need. So let's start with what is a last will and testament and why do you need it? So I'm going to turn off my camera at this point so you have a better look at the entire screen. All right, so let's begin with how does a last will and testament differ from advanced directives? Both of them are legal documents. The only difference is when are these documents going to be used? For the advanced directives, the medical, the financial, and some of the other legal, like conservator and guardianship, those are for when we are alive and looking at end of life care. So when we pass away, those advanced directives basically pass away with us and they become voided at that point. This is why the last will and testament is key. So yes, the last will and testament is a legal document, but it's focused for what happens after we pass away. So this is the way that we pass a property to others. This can assign legal guardianship if you have minors or you are caring for an adult with developmental intellectual disabilities. So advanced directives is for when we're alive and end of life. And last will and testament is what happens when we pass away. So last will and testament, remember, it's a legal document and it describes how you want your property to basically be passed after you pass away. So it allows you to say what happens to the property. And that could be real estate, it could be knickknacks, it could be personal property, anything that you own. Also, it allows you to appoint a personal representative. Other terminology that is used is an executor or administrator. And this person administers your wishes that you have outlined in your last will and testament. So for the most part, Colorado gives a broad freedom of who you could give away your property to, but it's important to understand that if you're married or the way that you own property, that could change how you're able or not able to distribute property after you pass away. So we will touch a little bit more on this point. And also, because we're promoting advanced care planning for everyone over the age of 18, at different points in our lives, we're parents, we're grandparents, and we're caring for minors, and we might be caring for a person with a developmental intellectual disability. So we want to make sure that not only are we protecting ourselves and indicating what is to happen after we pass away, but that we also protect those individuals. And this is a great tool to do this. Now, the last will and testament is not the only tool. It's one of the most common tools, but we'll talk about some of the other tools. The other very important thing to understand is that Colorado is one of the few states that recognizes holographic wills. So what are holographic wills? These are wills that are handwritten, and there's some requirements. In all this information, I will give you the link. I use the Colorado Senior Law Book 2020 edition. It's a great resource for you to have, and you will have access to that link. So the requirements for a holographic will are the following. You need to be at least 18 years of age to complete one. Why 18? Because under the law, at age 18, we become adults and we become independent from our parental units. So this is why it's 18 years and older. You need to be sound of mind. So if you have a condition where you are not sound of mind, you would not be able to complete a last will and testament or a holographic will. Also, you must be doing this voluntarily. So this means no one is forcing you, making you write and come up with this will. Next, you could either handwrite it or type it, or use a computer and type it there. Also, and very important, you must sign, date the will in front of a notary, and you need to have 2 witnesses. And key is that these 2 witnesses need to be disinterested witnesses. What does this mean? These 2 individuals are not going to get anything from your estate. So they have no stake in the game. So that's why it's so important that they're disinterested. So whoever you include in your will, they could not be your witnesses. Your witnesses could be anyone else but the individuals that you're including in your will. Okay. Without your signature, without a date, without it being notarized, that document is not complete. So that is essential to completing a holographic will, that you sign, date it in front of a notary, and that you have those 2 disinterested witnesses. So when we have a will and we pass away, I get a lot of questions. Well, what happens? What is the process? Well, completing the will, getting it notarized, you're setting the plan in place. So there is a legal process, and this is called probate, where the last will and testament needs to be provided by the court. And this has to go through a process. This process is where that personal representative begins to manage everything, and it's without extensive court involvement. But key, you need to talk to your personal representative before you complete your last will and testament, so they know that that is a responsibility, and that you are making sure that this is a responsibility they're willing to take on. Also, there's another process if, and it's part of the probate process, but separate if you pass away and you don't have a will in place. So if your document fails to, and when I mean your document, your last will and testament fails to indicate a personal representative, the court will choose one for you at that point. So this is why it's so important to have that conversation prior to completing your last will, so you could have a personal representative. You could even consider to have a secondary person in case that something happens to the primary personal representative. You have a backup. So it's important that we understand that once we pass away, there is this process called probate where the will needs to go through, and that personal representative is assisting with that entire process. So if we pass away and we don't have a last will and testament, depending on our situation, there's different things that could happen. So if we're married, for example, if we're married and we don't have any children or any other descendants or parents, we just have our spouse, then our spouse is going to receive 100% of what we own. If we're single, that changes things, because now we're talking about, do you have biological or adopted children? If you do, then they will receive all of your property in equal shares. But if you have no spouse or children, then they're going to look at your parents. And if you no longer have parents, they will look at your brothers and sisters to receive your property. And at the end, if you do not have any living family or relatives, then the default is for the state of Colorado to get whatever property you have. So if you don't have any living family and you want to make sure your property, whatever you have, goes to a nonprofit or another organization of your choice, this is key to making that happen with the last will and testament. So just know that there is a process, and this list of individuals that would go ahead and get your property if you don't have a last will or in testament. It's usually easier if you've already outlined that and you have named people and you have noted who it's going to go to, because when we don't have a last will and testament, what we are doing is putting the burden on the court to do the research and figure out who is our spouse. Do we have children? Do we have parents? Do we have parents that are alive? Do we have siblings? What does that look like versus us completing that document and already giving that to the court and having that in place? So there are some restrictions, like I said, depending on your situation. There's things that you're going to be able to do and not do on your last will and testament. So property that you own in joint tenancy with the right to survivorship, you cannot just give away. Especially if the joint owner survives you. This means the other person that owns the property is still alive when you pass away. So it's very important that we understand how we own property in order for us to know, can I give the whole thing away? Can I give a part of it away? What does that look like? So the way that you own property matters. Also, you cannot give away property that has a named beneficiary. The perfect example here is a life insurance policy. We have to name who the beneficiary is. You cannot change that in a will. You would have to change the beneficiary directly with that company that holds that life insurance policy. Also, surviving spouses have rights to a percentage of the estate once their spouse passes away. So the next slide that I'll show you gives you the breakdown based on Colorado Revised Statute. So depending on how long we've been married to someone, there's a percentage. If we've been married more than 10 years, then we're talking about 100% gets transferred to the surviving spouse. Before then, based on the year, it's that percentage. So less than a year, 10%, 2 years, but less than 3, 20%, and so on and so forth, all the way to 10 years or more, the surviving spouse getting 100%. And this is why understanding these things is so important. So how long have you been married, and how you own property will impact what you're able to include in your last will and testament. So let me go over property ownership and how we own property, because once again, this is key. So we're going to use the example of a house. So for example, when someone says you're the sole ownership, we're talking about you're the only owner. When we talk about tenancy in common, we're talking about that you own the property with another person. So basically 50% is theirs, 50% is yours. Joint tenancy, that's when you also join it with someone else. This is typically used in either real estate or personal property, where you're creating that right of survivorship, right? So if you pass away and the other person is still alive, then they're able to continue to be owners of that property. So it's very important that we understand the difference. There's also life estate. So you own the property, or you have named someone else as the owner. While you're alive, you can receive income from the property until you pass away. So remember, all of these are different tools that are in place. So this is why for this webinar, we're not going to complete a step-by-step tutorial on how to complete a last will and testament, because everybody's situation is so different that it takes much more than completing something like a medical durable power of attorney or a living will. It's a much more complicated, and there's many more things that we have to consider. So understand that how you own property is going to determine if you can give the property away, or how you can give the property away. So some of the other tools that I told you about that are also used in addition to a last will and testament, or instead of the last will and testament, are these four in front of you. So the first one is payable on death. Payable on death, it specifically deals with your bank accounts, okay? The bank accounts, you could have payable on death, or POD, which you are naming a beneficiary. And this beneficiary will get whatever is left as a balance once you pass away. So this is something that you do directly with your banks. So you would have to contact your bank and have that, and have the name of the person or persons that you want to name a beneficiary. There's a transfer on death, and this is for stocks and bonds. And this is transferred to the beneficiary once you pass away. So payable on death is bank accounts. Transfer on death, those are for stocks and bonds. So if you have stocks and bonds, that's an option for you. The other is a small state affidavit. States that do not include any real estate interest, or they're not more than 68,000 in total property. That does not pass through survivorship, these assets might be able to be transferred. So depending on your situation, that might be a better tool for you. Or another tool might be a trust. So a trust is typically where the property is held under a trust. So think of it as an umbrella where you put all your items there, and you have an individual that is managing the property. And this could be used to reduce, in some cases, eliminate the need for probate, and it could be also beneficial for taxes. So depending on your situation, it's important to look at all the tools available, just like we have during when we're planning for medical, financial emergencies. That's the same thing with the last will and testament, and looking at what happens to us when we pass away. So depending on how much property we have, do we just have our home, or do we have multiple property, maybe on different states, maybe different stocks and bonds, maybe different accounts, policies. So we want to take inventory of all those things to decide what is going to be much more beneficial for me based on my personal situation. And this is why before you complete a last will and testament, I really encourage people to seek legal counsel to make sure that you understand what is most beneficial for you, especially if you have a significant amount of property, or you have stocks and bonds, if you have a larger estate. So let me address some of the questions that I'm getting here. Can beneficiaries be witnesses and sign a trust along with the owner of a trust? So the trust process is typically done with an attorney. So anytime that you have witnesses, they need to be disinterested for the most part. So if that's what you are trying to do is a trust, I would seek legal guardianship to look at what that process needs to look like, because depending on the trust, the requirements, once again, it's based on the particular trust that you're doing versus having something like a medical durable power of attorney that for every case, the same things need to be on there. There's multiple different trusts. So based on the trust that is most beneficial for you, I would say seek the legal guardianship to ensure that you are not causing any barriers by not having disinterested witnesses. Let's see. When I get it notarized, can two bank employees witness if the notary is at my bank, or is there some requirement that I have a prior relationship with the person, like a friend, to verify that I'm sound of mind? Thank you for asking that question. So wherever you get your document notarized, an employee of that bank or of that institution could be your witness. Typically, that's a little bit easier, because then those two employees are disinterested individuals and you're able to do it. So you don't need to have a prior relationship with your witnesses in order for your witnesses to be able to stand as your witnesses. Thank you for asking that question. Let's see, our next question. Should a checking account jointly owned be done through POD, payable on death, or is it necessary? So remember, all of these tools are voluntary. So remember that they're tools to ensure that whatever happens and whatever your plan is, things happen in that way. So if you mean for your spouse to have access to that bank account when you have passed and they're a co-owner of that account, then it wouldn't be an issue. But if something happens to you and your spouse, what is to happen to that money? So it's based on the situation. So is it just you passing away, or is it, both owners of the account passing away? What would that look like, and what would you want that process to look like? And I think without clarifying that, it's difficult to say this is a tool that you should consider now or maybe after. If your spouse is still alive, and the two of you have access to your bank accounts, then that's great. But what if one spouse has passed away? I would consider the POD on that point in time. If you don't have a spouse and you're single, I would highly recommend that you do have someone as your beneficiary based on the payable on death. So it once again, it goes back to your particular situation. Does the percentage of ownership to which a spouse is entitled listed in the chart you showed apply only as a minimum if there is not an effective will? So those percentages are based on Colorado law. So it looks at the years that you've been married, and there's that percentage associated. So that's the minimum. If you want to include more and you haven't been married for the 10 years, which is 100%, then you're able to do that. But at minimum, it would be that percentage based on the years that you've been married. My bank no longer offers employees to be witnesses. If that is the process that your bank has chosen, then at that point in time, if you know that your bank no longer does that, one of the things that you could do is check with your bank, understand their processes and procedures to notarize any document, and you could take your own witnesses at that time. Just make sure that your witnesses and you have proof of ID. So that could be your Colorado ID, your driver's license, your passport, military ID will also do. So what are the situations a trust is highly advised? So a trust typically is advised when an individual has a significant estate. We're talking about property, we're talking about businesses. In some situations, there's trusts, so individuals can qualify for Medicaid. So it's based on the situation, and looking at the situation, things might look better in a trust than in a last will and testament. So that's why when different things happen throughout, it's good to know that there's different tools. So if that tool is not meeting your need, you could look at the other tools. So trusts, there's, like I said, different type of trust. There's trusts that are done when we're alive. There's some that only go into effect when we pass away. There's others that hold our estate while we receive Medicaid services, and then whatever was used on our care, the state will get back from that trust. So it varies on the situation. Okay, so let me continue forward. Okay, best practices. Let me check the chat to address any questions before we go into best practices. Regarding spouses, I assume a divorced spouse gets 0%. So when you are divorced and you don't have any property owned um, in a co-ownership with survivorship, then that would be zero. But if you have not finalized and you don't have the divorce decree, then that's different. So if you have the divorce decree, that would be correct. Um, all right, so let me go forward with best practices. So before we can determine if a last will and testament is right for us, we want to make sure that we consider some of these best practices. We want to make sure that if we are married, that we are talking to our spouse and planning together. Once again, it's because of how we own property that it's going to impact what the best tool it is for us, right? So we want to be able to talk to our spouses. We want to make sure that we are taking inventory of everything. This is gathering all documents regarding property, bank accounts, stocks, bonds, annuities, any policies. So everything that we own, including cars, including real estate, if we have businesses, savings, all of those things. We need to gather all of that information because, once again, based on what we have and how we own it, a last will and testament can be a perfect tool for us, or maybe we need to look at other things. Also, part of this planning, and more as we become more dependent on technology, and now we have all these online accounts, it is also important to take inventory of these online accounts. So that personal representative that we name in our last will and testament could also handle those accounts. Why? Because now we do online banking, we have social media, we have all these different accounts that we create to do regular business, whether it's getting our groceries, whether it is purchasing, PPE, or making sure that we do anything in this world. Now we have to create these online accounts. And if we don't know how many online accounts we have, then that personal representative is not able to help us. The same thing comes into play when we're alive. If we're alive and we have all of these different accounts, and we need for that person that is going to help with our finances to know that we have all these accounts, and we have an account through Social Security. We want to make sure that that person is able to identify where you have a list of all those accounts and the information to be able to access the account and close it accordingly when it needs to be closed. So that should also be part of your planning, especially as we are becoming more and more dependent on having online accounts with different companies to do everyday type of business. The third item is verify how you own property, because remember, how we own property restricts what we're able to do with that property. So verify how you own things. Also, have conversations. People say have uh, the conversation. To me, it's not the conversation. To me, it's multiple conversations. And we want to make sure that we have as many conversations as we need, ensure to ensure that our personal representative knows what we're asking of them and what the plan is. We want them to have the opportunity to say yes, and we want them to the opportunity to say no, because we don't want them to ensure, well, we want them to help us when we pass away, right? The worst case scenario is that you've gone through the trouble of creating these documents, getting your plan prepared, and when it's time for that person to speak on your behalf, that person steps away and they're like, nope, I'm sorry, I didn't know, I don't feel capable of doing this. Then at that point, the court needs to step in, and they need to assign someone for you. So we just want to make sure that you have those conversations and that person has the opportunity to say yes or no, we need to change things and such. The other is, especially if you're caring for minors, whether it's your own children, whether it's grandchildren, if you're caring for an adult with developmental intellectual disabilities, make sure that if you're going to appoint a legal guardian for those minors or that adult with developmental intellectual disabilities, that you're having conversations with those individuals. Once again, we want to make sure that that person has the option of saying yes or no to that responsibility, because we want to make sure that those minors and those adults with developmental intellectual disabilities are also taken care of when we pass away. And it's an individual or individuals that have agreed and have prepared for them to take on this role. Also, I highly recommend for folks to consult an attorney. I know that consulting an attorney sometimes means we need to pay a fee. Note that there's many attorneys that are willing to do a consultation with you prior to you hiring them and actually going through that attorney. So whether you want to have one consultation or many consultations with different attorneys to figure out what's the best plan for you, you're able to do that. So I will definitely give you some resources where you could go ahead and seek some free legal consultations, so you're able to access that assistance. Okay. Also, if you already have a last will and testament in place, and if you want to change it, here are some things to note. You can change your last will and testament, but there is a process. So note that a last will and testament is valid until it's revoked. And you can revoke your last will and testament at any time. If you change your mind about any type of distribution, so you want someone to get a higher percentage than they were before, or you have more assets than you did maybe 5 years ago when you completed your last will and testament, and you want to change that distribution, you can. If you change your mind about who that personal representative is going to be, or if you change your mind about legal guardians for a minor or an adult with developmental and intellectual disabilities, those are all appropriate times to change your last will and testament. Once you've created a last will and testament, please never write on your will or scratch things out or anything like that. Doing that becomes very problematic because you are talking about a legal document that now it's been tampered with, and we never want to have the validity of your will be questioned. So once your will is completed, don't scratch things out and include other things. You could use a codicil to amend your will for minor changes, but if there's major changes that need to take place, then we're looking at starting over, so redrafting that last will and testament. So just based on those changes, those might look different. And once again, consult an attorney. Some individuals have last will and testaments that are quite old, that they completed 10, 15 years ago. So some of the changes might be minor, some of the changes might be larger. So depending on your situation, it's always good, like I said, to consult an attorney just to make sure that to review at that point to see if a last will and testament is still the best tool for you and what other things you could do. So let me go ahead and answer some more questions that are coming in. So what is a codicil? So that is another legal document that is basically an amendment, an attachment that goes along with the last will and testament, basically saying that as of such and such date, these changes have been made to this last will and testament. Next question, can my personal rep transfer money in and out of online accounts without going through the online banks involved using my password? So understand that this is once you have passed away. If you need assistance prior to passing away, then you need to complete a financial power of attorney. That is one of the webinars that we did. So I highly recommend that you watch that webinar. And to ensure that you give your agent, your financial agent, the appropriate powers if you want them to use your online accounts, then you're able to include that on your power of attorney, and you would need to make available to them that information. So that way it's not only do they have a copy of the power of attorney, but they also go through the process of knowing where your login and password is. So just understand that anything that they do on an account when they're the agent under a financial power of attorney, they do need to keep track of all of those things. So they need to keep records of any payments, any transfers, any distributions that they've done. I hope that answers your question. Important to share online accounts, passwords with personal representative. So this is not written in question format, but I would say, yes, it's important for you to keep record of this information and to provide access at the time that is needed. So what do I mean with that? I recommend for everyone to have a file that has all their important documents, including your accounts and your passwords, and let your personal representative know where to find those documents. If they don't know, then they're not able to assist, right? So if they don't need to know at this period in time, then you don't necessarily have to give them inventory of all those documents, but you should have it set up where at the time that they need it, that they could access that. So whether it's a safety box in your home, whether it's a lockbox in the at your local bank, whatever that process is, that they know where to find these things. just to ensure that everyone's on the same page and to ensure that those that information is kept safe. And why do I say kept safe? I'm not saying that your representative is not a trustworthy person, but we live in a world where we're exposed in the online world. So we don't want them to necessarily be saving something that is not encrypted or protected. So those are some security measures that we want to take to ensure that if they're going to access those accounts and they have the login and the password, that all of that information is kept encrypted and safe. So your information doesn't get hacked and now someone has access to all of those accounts and passwords. So if you want to have them in a encrypted flash drive and have it in a safe place, that's a good method. So that way it's only being used and updated as needed instead of stored in someone's computer, if that makes sense. But yes, I would say it's important to have a plan in place to share those online accounts, the password and the sign in and that information. So next question, if an attorney in another state did your will, is it valid here in Colorado? So yes, your will is valid. I would, best practice, I would always annually just look at all my documents to make sure they still reflect what I want and my needs. And if at any point they no longer reflect my wishes and my preferences at that time, you could go ahead and change it. You just need to make sure that once again, whoever you have listed as your personal representative, that they know where these documents live. Next question. What is the difference between a personal representative and an executor? There's no difference. There's just different words used for the same person. So an executor and a personal representative do exactly the same thing. But in some documents, they might have personal representative and other documents might use the term executor. But it's basically, they have the same power or responsibilities. How do we access previous videos, like seeing this one again, or the first two you did in the series, like the financial power of attorney? Once I email you, I will go ahead and include a link on there to the playlist to all of the advanced care planning videos completed in this session. So I will include that in my follow-up to you, so that way you could watch them. You could also subscribe to our YouTube and go back and watch them whenever you want to. Those will permanently live there. So you could watch them once, you could watch them 20 times, or every year as you look at reviewing your documents, just to make sure that you're up to date with them. So I will give you that link, and anytime that you go to YouTube, you could search Colorado Gerontological Society, you could click on our channel, and those videos will be there. Rick, what do you mean? How about after death? Can you expand on that so I could understand specifically what you're asking me, please? Okay, so, all right. At this point, I don't have additional questions. So Rick, I'll give you the opportunity to expand on your question so I could go ahead and answer that. Let me go to the next slide. And the next slide, I have links. Once you have access to this PowerPoint, everything that is underlined, there's a link to it. So these are all resources for you to use. So you could get our advanced directives toolkit, click on that and you'll be able to see the medical, financial, legal. Here's the link to directly to the financial, the medical advanced directives. Here is the link to those advanced care planning webinars that we've done previously as part of the series. And there's some additional resources here on your left hand. So you have the Colorado Bar Association. They have a pretty cool tool that you could use. And this is what I mean with getting some free consultations. You could say what type of attorney you're looking for and also how those attorneys get paid. So you could say that you want, they have free consultation there. You could click on the free consultation and it'll tell you all of those attorneys that are doing elder law that give free consultations. All of those individuals will pop up. So Colorado Bar Association, it's great because of that tool, and everyone that is licensed under the Colorado Bar will be listed there. The Colorado Senior Law Book is another great resource for you to have. It has great detailed information. For example, the financial power of attorney that we used comes directly out of the Colorado Senior Law Book. Metro Volunteer Lawyers is a Metro Denver based organization, and they help with different cases and different civil matters on a volunteer basis. You could go ahead and give them a call or click here to go to their website, Colorado Legal Services. Give them a call too. They are able to assist with advanced care planning, including last will and testaments. The National Academy of Elder Law Attorneys. This is another way, similar to the Colorado Bar Association, where you could look for attorneys in your area. And the same for the American College of Trust and Estate Counsel. These are all resources that are free and that you are able to use at any time. So some more questions have come in. So let's see. Is there any way to get the PowerPoint slides on the presentation in this series, which were not attended? Yes. So once you go to YouTube, there's a video description at the bottom of each video, and each video description has exactly that. What is the video going to cover, and a link to the PowerPoint and the link to any other resources or forms given. So any of the previous webinars that we've covered will have that on YouTube. So feel free to check on there. Or you could always give me a call or email me, and I am more than happy to share that information with anyone. In front of you, you will see my contact information, so you could email me at maria.madrid@senioranswers.org, or you could give us a call and I'll forward that information to you, but it's included in every video in the video description box on YouTube. Let's see. So Rick, you said add after death to the above question. I'm sorry, I'm still not understanding what your question is. How about after death? So if you want anything managed after you passed away, that's the entire purpose of today's webinar. One of the tools that you could use is your last will and testament, and anything that the personal representative or executor, whatever you want to call them, you could be as specific how you want that person to manage any of your finances, your state. Just you need to make sure that it's listed on there and they have access to this. Of course, if you have other things like payable on death, that personal representative is not going to be able to manage that account because the bank has, if the person passes away, whatever remaining balance needs to go to whomever is the beneficiary. So depending on how you have things set up, that's how your personal representative needs to go ahead and manage things. Once a person has passed away, the personal representative is responsible for notifying all accounts and closing all accounts. So before they go into an account, they need to notify the bank that you have passed away. They're your personal representative. They'll have to obviously prove that you have passed away. So they would need a death certificate to be able to manage whatever account or whatever property or whatever else is listed on the things that they should assist you with. I hope that answers your question. Final call for any questions. Otherwise, you will get 5 minutes back. But either than that, let me thank you for participating in today's advanced directive webinar. This has been 3 months of me talking to all of you and sharing all this information. Next month, we have on April 16th, National Healthcare Decision Day. And my goal was to have this webinar series in hopes to inspire, promote advanced care planning, and hoping that you could join us on April 16th to complete your advanced directives if you haven't. To update your advanced directives if you haven't done that in a while. We will provide free assistance on that day. Email me. I'm more than happy to set up a time for us to go ahead and look at your documents and also get them updated if need be. So I hope that all of these webinars have been of assistance to you in your advanced care planning journey. I will make this recording, the slides available to you, along with all the other webinars that we have done on this series. So thank you so much for being here, for engaging in this topic with me. Be well, and you will get an email from me later on today. Have a wonderful day.